Okay, ladies and gentlemen, welcome to the US Patent Webinar Series hosted by DUT, Dongguan University of Technology. Today's webinar is the first one of our 6 lectures we are going to run in the coming 2 weeks. We hope to see you all in the remaining webinars as well. 大家好，非常欢迎来到由东莞理工学院主办的美国专利系列讲座。今天是本系列讲座这个6场中的第1场，另外5场将会在接下来的2周时间内呢陆续进行，欢迎大家届时准时参加。那开始介绍这个我们今天的演讲嘉宾之前呢，先对我们主办方东莞理工学院以及东莞理工学院知识产权学院的龚宏斌教授大力这个前期的这个工作和这个大力的这个支持表示感谢才有了这一次精彩的美国专利系列讲座。那现在呢，我们就正式进入今天的第1场讲座。那首先呢，请允许我简单介绍一下今天我们的主讲嘉宾。So now, may I have the honor to introduce our guest speaker today? 今天我们的演讲嘉宾呢是 Jessica Harrison 律师Jessica 呢是美国 Resolute Legal 知识产权事务所的合伙人Jessica 女士呢在知识产权领域呢经验这个非常的丰富，她在美国专利局从事了这个审查工作25年任职是Supervisory Patent Examiner 这个管理级审查员。同时他还在这个 TTAB 进行这个专利的上诉以及无效审理工作。Jessica 女士呢我本人呢很荣幸，我们呢是在美国富兰克林皮尔斯知识产权法中心的这个同班同学所以呢这一次呢也是非常高兴能够请到老同学来给大家就这个美国知识产权专利体系做这个第1讲开讲。那关于这个 Jessica 女士的更多这个资料呢，大家可以到Jessica 女士的这个公司 Resolute Legal 的网站上去详细了解。今天呢我就不占用了过多的时间来介绍。So let's warmly welcome our distinguished guest speaker today, Jessica Harrison. So, Jessica, now the floor is yours.
Good morning. Good morning. Good morning from Virginia. Well, thank you for that introduction, Ben, although I'm not certain what you told them. But I appreciate the kind words. Today we're going to talk about the basics of the U.S. patent system. I believe you've been told that I worked at the U.S. Patent Office for many years, which is true. And so we're going to cover the basics, the objectives that we have for today, that I'd like to make sure everyone is aware of is the basic forms of intellectual property that we have here in the United States, which encompass trademarks, copyrights, trade secrets, and patents. And then we're going to speak about the basics of a United States patent. I'm going to cover what may be patented in the U.S., who may apply for a U.S. patent, the term of a U.S. patent, and then we're going to briefly cover the legal standards, the variety of legal standards that must be met in order to obtain a U.S. patent. So my understanding is the 6 seminars that you're going to be having over the next several days, 10 days or so, are going to complete the, show the entire process about US patents and what can be done. So hopefully today I will be able to give you a foundation of understanding of what we will be talking about through the course of these seminars in terms of patents. So let's get started. In the beginning, on the foundations of the United States Constitution in 1776, the framers who built the government that we have here in the United States wrote into our Constitution that our Congress shall have the power to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So this is the language that serves as the foundation for the intellectual property system here in the US. It provides a basis in our Constitution for patents and for copyrights, which have been a part of the United States since our beginning. Now, trademarks and trade secrets are based in statutes that were later passed by our Congress to create those forms. But patent law and copyright, the protection and promotion of science and art, came with us in the formation of this country from the laws that were in place and the systems that were in place in England. It's something that that the founders of this country brought with them from England. So copyright came out of the British Statute of Anne, is what they called it in the 1700s in England. And the British Statute of Monopolies became the foundation of our patent system. So our founders in America took what they knew from England and implemented the system here in the US. What we have in the US is a system where we have different forms of intellectual property that cooperate and serve to protect different aspects of a business asset. And I use the term here business asset because it could be the product, it could be the method, it could be the marketing around the product, it could be how the product is made. All of these things have different positions and different aspects and different needs for protection for a business to have. And so they are all available to be used as they can be for any particular asset that a business may have. The first one that I want to cover is copyright. Copyright protects a work of original authorship fixed to a medium of expression. So this includes writings, novels, plays, music works, dramatic works, television, pantomimes, dance, choreographic work, artwork, sculptures, architectures, motion pictures and audiovisual works that encompasses video games. Basically anything creative that can be fixed to a medium, even if it's a live performance, if it's recorded by video, it's fixed to a medium. And the copyright by our laws arises at that point of it being affixed. So the copyright holder naturally holds the right. And this right is actually a bundle of rights that gives the creator the right to control the reproduction of that work. We also have a registration system via the U.S. Copyright Office. Now, you do not have to register your work in order to hold the copyright. However, if you wish to enforce the copyright, there are great advantages to have registered the work. And so it's recommended that artists register their works with the Copyright Office so as to preserve their rights to protect that down the road. For a normal business, they could have copyright arising in the text that they write on their web page describing their business, or in the operation manuals that are created for a product. These are just two examples that come to mind right now of things that are commonly subject to the copyright protection and what the business owner may be able to protect in their business asset. Moving on, we have a trademark system here in the US that helps businesses protect the goodwill that they develop between themselves and their customers. Businesses work hard to gain repeat customers and customers that rely upon their product and their product's image and their product's name. And so they can create names or logos. I have a few examples on this page that I think you guys will recognize. You know, to associate that goodwill with. So when a customer goes to select a product, they can be confident that that product actually comes from the source that they believe made it. So trademarks can go for can cover products or services. They would be called service marks is a form of trademark. There is a federal registration system in the United States for these marks that requires use of the mark in what we call interstate commerce. And that basically means that you're just selling a product, you're doing a business within the US. The trademark can last indefinitely if it's properly protected and not allowed to become generic. And it comes with a basic 10-year registration term that can be renewed indefinitely as long as the mark continues in use. We also have trade secret protection in the United States available. And it's often a very overlooked form of intellectual property protection. Trade secret law is based in contract. It may offer indefinite protection, but by contract, I mean in employment contracts, there's language that prevents disclosure of what you learn in your job. Non-disclosure agreements and employment agreements that you won't tell competitors what you know about your employer. It can cover any information that derives independent economic value from not being generally known to others or to the public. So often, the processes of manufacture may be kept as a trade secret, but also the customer lists of the business may be kept as a trade secret. The cost of this form of protection is the cost and efforts of reasonably protecting the secrecy of the information. And we have a set of laws that set forth and prescribe the standards around which disputes of trade secrets are judged. As a broad example, I note Coca-Cola. The formula for Coca-Cola has been held as a trade secret for hundreds of years. The formula, the recipe for Kentucky Fried Chicken, what is involved in creating that flavor in that product is also a notorious and well-known trade secret in the United States. So those are just examples of trade secret law and how that can be used by a business to help protect assets. And the last form, and the form that we're going to speak about for the rest of today, are patents. And the US has a long history with patents. That's at a broad level, what a patent is a limited duration property right granted by the government in exchange for a public disclosure of the invention. And we refer to it as a quid pro quo system. It is a balanced system that encourages not keeping new ideas secret. It is in tension with the trade secret law, which is to not tell anything about the idea versus to lay it open. The word patent means to lay open. And so we encourage, the patent system in the US encourages innovators to lay open their ideas and to share their ideas. And in exchange for that sharing, they are granted a limited term right to exclude others from making, using, offering for sale, selling, or importing the invention into the US. By making it public, it encourages other people, it inspires other people who come later to further improve upon that which is done before. So it's a self-renewing cycle. The patent itself allows for the creation of property via a legal instrument from an idea. It is not a tangible property like land, which you can own and take a mortgage against, generate economic wealth from. It is similar, however, as an intangible property because you can also receive funding for a patent, take out a loan against the rights of the patent, and therefore build a business with it. So it is a way to create wealth and property out of ideas, out of nothing. And that enables financial gain for the patent holder on many levels. In exchange for this disclosure from the inventor, the public has the ability to use this invention freely when that patent term expires. So that supports free market competitive forces. And it promotes the progress and development of new technologies because investors may protect their investment. And as I mentioned earlier, the disclosure of the idea will inspire new ideas and the cycle of innovation continues. And we have over 11 million patents that have been granted in the United States in a little over 200 years. And so the system continues to grow. We have a United States president named Abraham Lincoln, who was the president in the 1860s, who was also a patent holder. And he famously quoted, "The patent system adds the fuel of interest to the fire of genius." So these are all a part of the business culture and background and the importance of patents in the United States.
反正就是这种都是疫情骗子。
就把我骗了之后，我过几年又去了之后，我就是真的报警。
So in the United States, what can be patented? We have 3 types of patents in the United States. The first one is a utility patent, which is what I'm going to speak about most in the rest of this talk. A utility patent can be granted for any new and useful process, any new thing that is manufactured, any new machine, any new composition of matter, or improvements to these articles. The US also has what's called a design patent. And a design patent covers the ornamentation of an article, the shape of the article, the ornamental design for an article of manufacture. You can think about the ergonomics or the shape of your phone, or the ergonomics or the shape of the computer mouse, how it looks, not what it does. What it does, what it is, or what it does would be a utility patent, but how it looks, its ornamentation, is a design patent. And we also grant patents for new types of plants, which is any new and distinct variety of plant that is invented or discovered and asexually reproduced. So plant patents, which are a very, very small area of patenting, but very important. Rice that can be grown with much less water is protected by a plant patent. Variations of flowers and their colorings are protected by plant patents. But the overwhelming majority of patents in the United States are utility patents, those things that cover processes, manufactures, machines, and compositions of matter. Who may apply for a U.S. patent? Anyone from anywhere in the world may apply for a U.S. patent with only one exception. Officers and employees of the United States Patent Office are restricted from patenting or owning interests in patents while they are employees of the Patent Office and for 1 year after they leave employment of the Patent Office. So no, you do not have to be, there's no nationality requirement to take advantage of the U.S. patent system. Anyone from anywhere in the world can be named as an inventor on a U.S. patent. 10 years ago, basically 10 years ago this week, we had a large change in the patent laws in the United States. It was a law that was passed called the America Invents Act, or the AIA as it's referred to. And it brought sweeping changes into US patent law, which included a shift, a fundamental shift in our system from abolishing historically the first to invent being rewarded with the patent to the first inventor to file being rewarded with the patent system. So that's another way to look at who may apply for a patent in the United States. The first inventor to file will win the race to the patent office. And this change has, the last 10 years have brought about a lot of changes to our system, and we're still getting used to that here in the US. But it has resulted somewhat in a race to get the disclosure on file at the patent office. It has changed the way patent attorneys do their business a lot more than anyone else, basically, because we have to get the invention disclosed and on file to get it in line quicker than we used to in that race to the first. But it also brings the United States more in line with the rest of the world, and the change is part of a step in harmonizing globally patent rights. But I did want to mention that here at this point. The term of a patent in the United States, the limited term that is in our Constitution, has been set by our lawmakers as 20 years from the earliest claimed priority date. So we do have the ability to claim the benefit of earlier filings in the United States, but that does not extend patent term. So it's 20 years from that earliest claimed priority date, and it is subject to the payment of fees to the government. In the US, when you receive a US patent, at the end of 3.5 years, 7 years, and 11.5 years, 3 times, you have to pay fees to the government to maintain the right to enforce that patent. And that is to ensure that patents of value will continue to be used, and patents that are not being used cannot come back to life, so to speak. As well as it helps fund the patent office, because the United States Patent Office is not funded by the government as a whole in general. It's funded by user fees. So those that use the system pay for the system, not everyone. And so the maintenance fees are part of that funding of the patent office process as well. So we have a variety of laws in the United States that set forth the standards for obtaining a patent here. We have a law that describes what is eligible for a patent, and that is 35 USC section 101. We have a law that describes and sets forth the clarity and completeness of the disclosure, as well as the patent claim. And that law is known as section 112. we have a law that requires patents set forth new inventions. And that law is referred to as Section 102. And we have a law that requires the improvement, the difference between what has been invented and what was known before be legally non-obvious. And that is known as Section 103. So we're going to cover the basics of each one of these in just a moment. But overall, a patent application in the United States has several parts. It has a specification, which is the written description of the idea of the invention. It has drawings, which illustrate the invention. It has an abstract, which is a short, brief description of the invention. And it has at least one claim. And the claim is the legally operative part of the patent. The claim is what defines the scope of the invention by which our court system will judge whether or not someone is infringing. So it's often said the claim is the name of the game in the US. The claims are extremely, extremely important. And what the claims are what the lawyers argue about and the businesses argue about. It's also what the patent examiner searches, researches, and compares to the prior art. It's what gets examined in the patent application. It's the scope of the claim. So this first statute that I mentioned, the eligibility statute, 35 United States Code, Section 101. Without question, this is the most legally active area of US patent law currently. Innovators are creating new technology at a very, very fast rate right now. Technologies that fall on the edge of what was defined over 200 years ago as the statutory classes of a process, a machine, a manufacture, or a composition of matter. Nanotechnologies, where do they fit? Computer software, where does that fit? Artificial intelligence, where does that fit? We don't really know because these technologies did not exist many years ago when the system and these classes were codified into our laws. And so technology is moving beyond what the US laws describe at the moment. And there's lots of legal argument about whether or not something is fundamentally eligible to receive patent protection in the United States. The patent office and the US courts are struggling to keep up with this expansion of technology right now. As I explained to my clients dealing with cutting edge technology, technology moves very fast and it is just increasing. It's getting faster and faster. And law moves very slow. Change in the law moves very slow. And so there's a lot of uncertainty in this area of the law right now. Certainly in the US, throughout the world too, but it's definitely a big concern in the United States as new technologies come online. There are two criteria for determining whether something is even eligible to receive a patent in the US. And one is that it must be directed to a process, a machine, a manufacturer, or a composition of matter. And as I noted, there are current new technologies that it's not really clear whether or not they fit into one of those categories. And the other requirement is that it must not be directed to subject matter that a court has determined is not allowed. And so we have certain areas of technology where a court has now determined that we're not going to grant a patent on. And some examples of that I put on here are signals, transitory forms of signal transmissions, signals per se. Can't get a patent on a signal, on an electrical signal. Humans, you cannot patent a human per se. You cannot get a patent on a way of settling disputes through legal contracts. You cannot get a patent on mere arrangements of printed subject matter on a substrate. So you cannot get a patent on data. You cannot get a patent on laws of nature or things that are deemed natural phenomena. And that includes how the human body reacts to certain drug compositions. So, a drug is clearly a composition of matter. A drug is a patentable subject matter, but not when you're trying to claim the operation of the drug in the human body if it's behaving naturally. Mental processes, certain methods of teaching, for example, have been deemed unpatentable. The policy can be summarized as the basic tools of scientific and technological work are not patentable. But there's a lot of confusion in this area of the law, and there's a lot of litigation in this area of the law, particularly where new technologies are pushing the limits of what the law allows. And one of the big issues in this area right now is the concepts of artificial intelligence. Can AI invent? Is AI an invention? That legal tension with AI is going to be fought out in the U.S. courts soon. So, this statute, 35 U.S.C. Section 101, also requires one invention gets one patent. So it allows for the basis of double patenting rejections. You cannot claim the same invention twice. And that's identical scope, the same invention. You have to vary the scope, therefore change the claims to do that. This statute requires that the proper inventors be named. So it sets forth the requirement that the patent be granted in the name of the inventor. That does not mean that the patent cannot be owned by someone else. That's a separate operation. But this statute also requires that the invention have a specific, substantial, and credible utility. So this prevents the ability to attain a patent for a perpetual motion machine, for example, things that are outside the boundaries of known physics. You cannot have a patent that claims a cure for a disease such as cancer, but you can have a patent that claims a therapy or a treatment for a disease such as cancer. So that goes to the utility requirement that it have a credible, useful function. The next statute that is important in a standard for obtaining a patent in the United States is 35 United States Code Section 112. And this law requires that the disclosure be complete and clear, and that the claims be complete and clear. So this goes back to what I mentioned as that quid pro quo exchange, that in exchange for telling the story of your invention and its details, you get the limited right to enforce and prevent others from using it. That means that to tell what the invention is, you must have a written description that is sufficient to show that you have possession of the invention. And this is a mental formation in the mind of the inventor, a formation in the mind that is complete. So you have to write your description clear and precise enough to demonstrate you have thought the invention all the way through. There is not a requirement that the invention be made, which in the US we call reduction to practice. But there is a requirement that it has been formed in the mind of the inventor completely. And you must also describe in your disclosure the enablement. It must be written precisely enough so that someone having ordinary skill in that technology could make and use the invention. So you have to disclose the details of your idea. And in that, you have to establish a best mode for creating that invention. You cannot hide the best preferred way to do something. Everything about this statute and the patent in the aspect to lay open is about telling enough about the invention to serve the public policy purpose. And that extends to the claim language, to what you are defining as your invention. You have to have at least one claim, and it must particularly point out and distinctly claim the invention. It cannot be vague. It cannot allow for variations, because the claim is about telling the public and telling the court precisely what the invention is, the scope of the invention. We also have a couple of other statutes that require these are the two laws that regulate the comparative nature about whether or not the patent should be granted in terms of what other people have done. So there's a requirement in a law known as 35 United States Code Section 102 that what has been invented is completely new. It's a requirement for novelty. And that basically sums up to the exact same thing has not been done before. But in order to make that comparison, we need to know what we are comparing against. And so this statute also defines what we are comparing against. This is the law that tells everyone what constitutes prior art, what can be used against a patent applicant to deny their patent. Most commonly, the prior art is other patents from anywhere in the world, published patent applications from anywhere in the world, and what is known as non-patent literature from anywhere in the world. Books, scientific journals, published research articles, web-based publications, and applicant admissions. It is also possible that an applicant may admit things in their disclosure that can be used against them to deny a patent. So this is a very important statute in terms of what it brings to this system. The definition of prior art and the requirement that a patent claim describe something that is novel. A second statute is 35 United States Code Section 103. And this requires a patent to be granted on a claim that is, in addition to novel, also non-obvious. The standard by which this non-obviousness is judged is what one of ordinary skill in the art at the time of the invention would have considered to be obvious. And it's a legal standard. It's different from what a scientist or an engineer might think of being obvious. It's a legal obviousness that has a formulaic application in the United States, and that is, we determine the scope and content of the claims, and we determine the scope and content of the prior art, and we isolate the differences. And then we ask the question, would that difference have been obvious to one of ordinary skill in the art? And we ask that question in terms of combining various pieces of prior art to result at what has been done. So this is where the majority of patent prosecution comes into play, is the arguments. The patent examiner will create a combination of prior art references and assert that the invention's difference is obvious from looking at that combination. And the patent applicant then has to come back and argue why it would not have been obvious. So this is where the majority of patent prosecution occurs, is in this debate about these differences between what has been done before and what is currently being claimed. And that brings me to a consideration of the process of obtaining a patent in the United States. I think the process is very similar to the process in China and in most other areas of the world. An application gets filed. There is a first examination. It usually results in a rejection. Sometimes it can go straight to a patent, to a notice of allowance and a patent. But usually there is a rejection. And the patent applicant can file changes to the scope of their claims. They can file an amendment to the claims, and there's a second examination. It can go to a third examination. That process can continue to go back and forth, but usually the second examination, the examiner says no a second time, and basically they say no, final answer, and that triggers an appeal process or a refiling of the application and trying again. So in the US, you get, for the price of your filing fee, you get 2 examinations. You get 2 looks by the office at your invention, 2 chances to convince that examiner to give you a patent. And then you have to pay the fee again. You can continue the examination and pay the fee again and get 2 more shots at convincing the examiner. Or once you've been twice rejected, you can appeal, and you can ask the Patent Trial and Appeal Board to take a look at the examiner's evidence and your arguments and make an independent determination about whether you should be allowed a patent or not. So that's the basics of the US patent system. And what I had to cover, and I wanted to leave a lot of time to address questions from the audience about what I've covered or about what I haven't covered that you have questions about. So that's what I'd like to use the remainder of our time together to answer your questions. So, Ben, would you like to take this over? Would you like to, me to end the slide share?
Yeah, sure. Thank you, Jessica, for the nice talk. 好的，各位，稍等一下，等我切换回来我们的这边这个背景。看看大家有什么问题吗？Jessica 就美国的整个知识产权体系啊，应该是做了一个比较全面的一个介绍，并且呢，重点给大家讲授了那个美国专利制度啊，像它这个来源，以及几个重要的这个法律条款啊，包括可授予专利权的客体，这个新颖性创造性条款，以及可能另外一个就是对应我们国内的这个叫支持啊不清楚的这个和说明书有关的这个条款啊。Yeah, no problem, Jessica. You can leave this slide on. Yeah. 然后现在 Jessica 老师展示的这个界面上呢，也有Jessica 老师的联系方式啊。大家注意到 Jessica 老师他这个邮箱里面有一个是UNH Law 的这个邮箱，实际上 Jessica 老师呢也在，就是说我们之前一起读书的那个美国法学院呢， 啊，也在那边呢，也是兼职给法学院的学生呢教授关于知识产权，尤其是专利的这个理论以及实务的课程啊。
刘老
Jessica 老师
师，
呢，不仅是在这个专利的审查阶段，这个专业经验非常丰富啊。我一开始也提到，就是 Jessica 老师呢，还是那个 PTAB 的这个审查员。所以呢，后续还有另外一门课呢，Jessica 老师呢，到时候会就这个美国专利的授权后的一些这个程序啊，以及一些实务操作呢，做另外一个课程的讲授啊。现在呢，我们就把时间呢交给大家各位，看看大家有什么问题啊。
Hello,
Hello.
can you hear? Jessica, hello.
Hello.
可以听见。
Okay,
Joy，
very good. This is Dr. Dong, and I have a quick question regarding the difference between ownership and inventor in terms of, for example, either copyright or patent. Can you say a few words about ownership, the owner and the inventor? Thank you.
Yes, in both copyright and in patent, the owner can be different than the inventor or the artist. These are separate concepts in America. And there's also the concept of applicant, which is a third concept here. But an inventor, the rights arise under our laws to the inventor for patent and to the creator for copyright. So the law naturally vests the right to the inventor or the creator. The inventor or the creator may then contractually assign that right to an owner. And that's a completely separate legal transaction from the obtaining of the patent or the registration of the copyright. So a patent, once it's issued in the name of the inventor, it may be applied for by an applicant, such as the inventor's employer. Someone else may make the application on behalf of the inventor and perform the prosecution and secure the right, but the right itself resides with the inventor until that inventor, by legal contract, transfers, usually for consideration for a dollar, a reasonable dollar amount, to a patent owner. And then the owner has certain rights with the patent. Usually the assignment comes through employment contracts. In America, when you work for a company, you usually, in exchange for your employment, have agreed to assign any patent rights you obtain to your employer. However, there's plenty of independent invention that goes on, and plenty of inventors that sell or assign their patent rights to a company. And companies may then, by legal contract, sell or transfer those rights to a new owner. And we have a recording system. We have a system for recording who owns each patent. And that is the recording of that ownership is done through the assignment branch at the USPTO. So you can publicly, There's no requirement that you publicly record them, but there is a public recording system available where you can research who actually owns the patent, because the owner is not going to be listed or printed on the patent, and the owner can change over time. But that can be available information or publicly recorded through the assignments office. It's handled like a regular property transaction after the patent is granted. And
Yeah.
very similar with copyright as well. There is an assignment. The copyright, the creation may be a work for hire. That is, you may create as part of your job, and therefore who hired you owns the copyright by assignment. So I hope that helps you understand the differences here.
Yeah, thank you very much. It's very clear. Just to be more specific, for example, given the copyright is issued to an author, in one of the slides you mentioned that life cycle for that copyright can be the life of the inventor, the writer, plus 70 years.
Yes.
But considering that ownership may be transferred to a company, and does it actually tracked by law that how long this author will live, or how it works actually? When ownership turns from the writer to the owner, once the copyright transferred, usually the author is no longer to track, even paying the fees anymore. So what is the situation in reality? Thank you.
That falls on the copyright owner to track, because it's their responsibility to enforce. And so it's their responsibility to know whether they have the right to enforce. And, if they assert a copyright, the other side, the accused, is absolutely going to see and do the research to see if that original author, when they died and whether or not that copyright is still enforceable. So this is a burden that is passed to the owner and to the accused to determine, but it absolutely is currently the life of the author plus 70 years to their estate, and that doesn't change because ownership changes. That stays vested to the author.
Thank you very much. Thank you.
谢谢鲁博士的提问，看看大家还有什么问题啊？这个机会难得。
Hello.
Hello.
Can you hear me?
I can.
Okay, I have a question about. Okay, first I want to thank you your wonderful presentation, Jessica. I have a question about the patent examination, the first examination and the second one. Here is one thing about the second examination that now you said usually it is the final examination. But in case, for example, in the first examination, the patent examiner says one document, let's say documents A, but in the second examination, he found okay, the documents A is not so suitable. Maybe document B is more suits better. So do the examiners issue a third examination even if the applicant don't pay extra fee, or the second examination is also the final examination? Because I want to know something about the hearing rule. Usually 2 times hearing is Okay, so I want to hear more about this. Thank you.
I understand your question, I think, and the answer is it depends. If the examiner finds a new piece of art on the second examination that is better, the question is going to turn about whether he should have found it the first time or not. And that is whether or not the applicant has changed the claim. So if there's been no change in the claim and they're looking at the second examination and they find a better or stronger piece of prior art, they have to show that to the applicant and give him an opportunity to respond. So they will not make that second examination final. And the applicant again has the right to respond to that. But if the applicant changes the scope of the claim in a large way, in a meaningful way, the examiner can pull another piece of art and use it to reject the claim and still close that prosecution. So what you're talking about is there the possibility of what is called a second action non-final rejection or a third action non-final rejection? And the answer is yes, it is possible and it does happen when it is clear that the first examination should have found that reference and did not. When it is the fault of the examiner or the office, the applicant is not punished for that. So, yes, I hope that answers your question.
Yeah, I get that. So it is mainly depends whether the fault is the applicants or the examiners.
Yes, and I don't like the word fault, but that is a good way to think about it. It's more of what caused the change.
Yeah.
Yeah.
Okay, I can understand that.
Yeah.
Oh, thank you.
There's
Hi,
a
Jessica.
question here in the chat that I'd like to
Yeah,
address, if
do
I
you mind
may.
look at the chat box?
Yeah, there's a question from Penny who wants to know how to define the entity of the applicant, especially between small and micro, the income basis. Right. Okay, yes. This has to go, this question goes to the system in the US for how much you pay for your application. And fees are set by the patent office based upon a very complicated formula of how much time on average it takes to examine a case versus how much it costs the office to examine the case. I mentioned that the office was funded by the fees of the applicants instead of funded by Congress and the US taxpayer. And so in order to fund by the fees, by the user fees, they have to calculate what those, what those costs are and balance it out. So the fees are set for what is known as a large entity. And that is a business with greater than 500 employees. It's a legal definition from the Small Business Administration that applies throughout the federal government, including the Patent Office for certain government services, what that entity size is. And they offer half price on those fees for what is known as a small entity, a business that has under 500 employees, or an individual inventor who is not a micro entity. And there is a third category that has been created to encourage independent inventors and small people, non-businesses, to apply for patents, and that is called the micro entity status. And the micro entity status is half price again, or 1/4 of the large entity fee. So if it's $1,000 to a large entity, it's $500 to a small entity and $250 to a micro entity. So that's how the fees, that's how the fees get reduced. Now, a micro entity, first of all, has to be an inventor or joint inventors that have not obtained more than 4 patents. So they're new to patenting, they're new to the patent system. I have an inventor who was a micro entity. He is a sole inventor that I represent. He was a micro entity. When he got his 5th patent, he had to become a small entity. So you have to have 4 or less US patents. And you have to have an income that some inventors you have to have, there are income limits to yourself as a person or your small business. And it's a complicated formula for what that income is and how they calculate it. But right now, it's about 180,000 USD per year. And so there are plenty of individuals who do not make that much money. There are not that many businesses that most businesses make more than that. So most businesses will be a small entity. But there are plenty of individual inventors or joint individuals, 2 or 3 individuals that each make that small amount of money. And so they can pay the small fees. So I hope that answers Penny's question.
Penny? I'm not sure whether Penny is still there or not. So,
Okay.
Oh yeah. Okay, yeah, I think Penny replied. Yes. Thank you. Thank you, Jessica. Also, thanks to Penny. Any more questions from our audience?
Okay, Professor Liu, and thank you, Jessica. Can you hear me, Jessica?
Yes.
Hello, Jessica. Okay. Thank you for your excellent lectures about US IP, especially for US patent. I'm Professor Gong, which is close friends with Professor Liu Binqiang. Yes, I'm pleased with your lecture. My question that is, would you tell me something about the most characteristic or most outstanding feature of the U.S. copyright law? This is a question. Another question that is, we also know that is in the United States, the company and the authorities pay more attention to protect the business secret. And China and the U.S. has signed a trade agreement. And the first part is mainly concerned about the protect the business secret. But I also close to study this agreement. This note I'm not fully understanding. It's talking about the party. The note is writing like that. The parties agreed that the term confidential business information, the blah blah blah. There's one type of this subject that is style of work, such as the operation style of works or apparent, or the produce, something like that. My question that is, when you just told us, you just told me that it's in American, the scope of the business secret is, I think, is very large. That is, the company, it did not disclose any information, it can be regarded as a trade secret. My question is that what's the meaning of the style of the work? Style of work, and the work is a plural form. I don't know what's the meaning of the style of the works.
So your question is, what is the meaning of the style of work in the trade secret agreement?
They include the trade secret or commercial information include the style of works.
I don't know the answer to that off the top of my head. I don't know. I honestly, I don't know what they mean by style of works. I would have to do the legal research to see what that means.
Okay.
I'm sorry. I don't practice in trade secret law. I refer that out when my clients have that issue. I refer that out to someone who practices regularly in trade secret law. So I don't know what style of works would mean. I'm sorry.
Okay. Thank you.
Jessica, maybe
Yes.
I can do some brainstorming. As we are constantly encountering trade secret in the company, maybe style of work can be considered as, the type of secrecy. For example, giving an invention is not disclosed in a company. That invention, the core is algorithm or computer or a piece of prototype. The style of work itself can be a secret. That means you don't disclose what is the core, what is the style of your work. That's my personal understanding. Maybe it's not right.
That very much may be correct. My understanding of trade secret law, super high level, is any information that can derive economic value by not being known can be a trade secret.
Yeah.
And so, it doesn't matter what it is. Probably it's not prevented by how the information is kept. It's just that it must be kept secret. Past that, somewhere, if they're saying style of works, my suspicion is that is something that is a term of trade secret art that has been litigated. It's going to have a meaning somewhere. I just don't know what that is.
Yeah, and generally speaking, that is in the U.S. that the scope of the business security is very large. That is any information, any disclosed information can be regarded. Yeah, anything.
Yeah, you just have to mark it as secret. You have to take steps to maintain it as secret. You have to tell people it's confidential and secret if you share it. You have to tell your employees the same thing. You have to take steps to protect it. If the information is held in a computer, you have to take steps to prevent access to that computer and to that information. If the information is held on a piece of paper in a filing cabinet, you need to put a lock on the outside of that cabinet that it's in. You have to take steps to protect it. But other
Yeah.
than that, it can be anything.
Yeah.
This is
yeah.
this is something that companies don't take advantage of in the US as much as they should. I have seen examples where technology companies, they have their employees on non-disclosure agreements. When they share information with partners, they have them under non-disclosure agreements. They are taking the steps to protect their information, and then they do not train or educate their human resource department about this. And their human resource department goes out to recruit engineers and tells engineers during interviews, we are working on this new technology, come work for us. And they completely give away the trade secret.
Yeah.
So when you're a company dealing with trade secrets, it has to be a global, all employees are educated and understand the trade secret idea and steps being involved. Trade secrets have been lost because of minor business errors, such as not educating all employees about the trade secret. That's about all I know on trade secrets.
Thank
More
you,
questions?
Professor.
Yes, Jackie, this is it's a kind of it's a systematic measure, protection measure for the company, for the business company to protect the business secret. Yeah. Okay.
Okay, any more questions?
Yeah.
Jessica,
Yes.
I have a question.
Okay.
Yeah, we know you're only an expert, in real world, practice. But of course, you are teaching also at UNH Law, So I'd like to ask you about your attitude toward a recent hot topic is about AI as inventor. How do you think of this? Do you think AI can be named as inventor or?
Well, do I think it can or do I think it should? I think that under the United States law, I think it's clear that inventor is defined legally as being a I don't know if you had muted me on that, but I think under the current US law, it's pretty clear that our laws define the inventor as being a human person. However, I personally think that artificial intelligence should be allowed to invent. I think the US law needs to be changed before that can happen in the US. But I think they should change the law. I think machines can create, and they should be able to bring those creations forward, and the owners of the machines be able to benefit from that creativity. So I think the law should be changed, but I don't think AI can be an inventor the way our current law is written.
Yeah, I think that's the conclusion one of the US District Court came to now.
Yeah.
Yeah.
I agree with that.
Yeah. While South Africa and Australia, I
Mhm.
believe they directly, agree AI can be named an inventor.
Yes.
Okay, cool. Thank you. So
Kevin has a nice question. Since post Alice, has software invention been getting easier or harder to be patented? Absolutely harder, without question. The Alice decision has wreaked havoc for 8 years in US patent law. It is much, much, much harder for software to be patented as part of an invention. I believe Alice is an appropriate decision for the limited facts of Alice, but I think Alice has been applied in ways by our courts that are way outside of the limited scope of Alice, and it kind of has just destroyed software innovations in the US and the ability to properly protect them. And I say that from a practitioner who practices mainly in technology areas that are software based. The large part of my personal practice and my client base is in two areas that have been extremely impacted by Alice, and that is the video game area. I represent a lot of video game companies, and in medical technologies, medical diagnostics, and medical treatment with software. And so we face Alice rejections all the time, and it's very, very hard to get patents on inventions that include software. So thank you, Kevin.
Thank you, Jessica, for giving a nice answer. 看看大家还有问题吗？抓住机会哦。
Hello.
Mhm.
Hello. Jessica, can you hear me?
Yes.
I want to ask a question that what do you think of about non-practicing entities? And do you think it exerts positive influence or negative influence in the US? And what can we do when we face to the non-practicing entities lawsuit? I want to ask about this.
What a fantastic question. These views are my own, and they are not the views of my law firm. But I think the patent system is founded to support all inventors, including those that have a business model that does not require them to produce a product. I think non-practicing entities, these are things such as universities. And where would research and science be without the contribution of research through universities? I think a non-practicing entity is a politicized term that has been created by large businesses because they do not wish to respect intellectual property rights. So I really dislike the term patent troll. I really dislike non-practicing entity because I see those as a business model separate from the invention model. I think the patent system is about ideas, creation, new technology, turning thoughts into things. And I think creative minds should be rewarded for their ideas, regardless of whether they ever create those ideas into a product or not. So, that's my personal take on the non-practicing entity. Yeah, I think they have every right to even those that form a business by buying patents and asserting them, that is a business model. That is not a patent issue to me. And so I hear somebody's child has an opinion.
Yeah, we have a
about
baby who wants to
non-practicing
join, you know. That's awesome.
Yeah.
Oh,
Okay.
how can I handle with
So,
that?
I hope I answered the question about NPEs.
Yeah, NGE is a very popular phenomenon in the US, and also just I quite agree with you, and I think that the NGE, from my understanding, is quite of the business model. Maybe they do something not so quite well, but from the commercial aspect, they do the business things.
Well, it's a separate issue. For me, it's a much more separate issue. And we'll talk more about this in my second talk later this week. It's a separate issue as to whether the patent was properly granted, and therefore whether the patent is valid and should be in existence. A lot of the time, a lot of the political pressure and problem around the non-practicing entity is that they tend to assert patents that perhaps were not properly granted in the first place and should be taken out of the way from preventing the public from doing what they're doing. And that to me is a completely separate issue, again, from the drive of innovation versus the business use of innovation. And that is some of the basis behind the new mechanisms to challenge the properness of the patent being granted. So in my next talk, and I hope most of you guys will come back for that later in the week, my next talk, we're going to talk about the ways to administratively, before the patent office, challenge a patent's validity, challenge its existence, remove its existence, or force a change and a narrowing of the scope protected by that patent. We're going to look at those mechanisms to deal with improperly granted patents, which by the most part will also impact the business entities using those patents.
Okay, okay.
Anything else?
Yeah, actually, regarding the NPE question, I think our audience also cares about what to do when one faced with NPE litigation.
冰强啊，冰强，有关那
Yep.
个冰强那个 NPE 那个以前那个案例，就是那个 change the Vanex or the jurisdiction place 这个案例出来以后呢，现在的 NPE 在美国的诉讼情况怎么样啊？我问一下 Jessica， 我不知道那个案例我记不清了，现在。
I'm going to need a translation, Ben.
Okay, Jessica, my question that is also I pay more attention to the NPE. I remember maybe 3 or 4 years there's outstanding cases that they changed the Vanex of the NPE. That because before that cases, a lot of the NPE launched the litigation in the East Texas, and now these cases change this the criteria of the jurisdiction. So post these cases, what has happened of the NPE litigation? What they choose the jurisdiction? Can you tell me something about this?
I can, and I can tell you that later this week, you're going to hear a talk from my business partner, Dan Ho, on litigation in the United States, and he will talk a great deal about this. But the case I believe that you're talking about is known as TC Heartland, and it addressed where you can sue in the United States. And so, you know, the Eastern District of Texas was a small, sleepy little town where people, businesses started suing on patent issues because it was a court that was not used. And so it was faster than, say, California court or New York court because no one was suing down there. And so everyone went to Texas because they didn't want to wait 3-4 years to get before the judge. And Texas became a large patent area. And the Texas judges liked patents and felt like they knew about patent law after doing so much of it. And so it became a huge patent venue. But it was, there was a case that put additional restrictions on where people could sue, could bring patent suits in the US. And so Texas, certain people that were suing in Texas really didn't have the standing, the legal right to sue in Texas. So they have to go back to their court, their court where their business home is. And for most companies in the United States, that is Delaware. Most businesses are incorporated under the laws of the state of Delaware. So a large amount of the patent lawsuits that were in Texas are now being brought in the Chancery Court of the state of Delaware. And in the Eastern District of the United States, instead of the Western Districts of Texas, the Eastern District of Virginia and the District Court in Delaware are now much larger places where these lawsuits occur. But
okay.
Dan Ho will be talking about litigation issues and where suits are brought in his talk on litigation later this week.
Okay, okay, we are looking forward to this nice topic.
对，那就先预告一下，就是后续那个Jessica 他们的合伙人 Danny 会那个就在美国的诉讼，尤其是地方法院、联邦法院的诉讼会做一个专题演讲。刚才我们那个朋友问的那个 NT 那个，也就是关于诉讼这一块的话，我简单分享几点哈。第一个，说实话，得要看这个 NT 的这个水平如何。哦 ，Jessica，excuse me。I'm just making a quick answer to the lady just asked about the NPE litigation. 说实话，如果是碰到的 NPE 是很专业的人啊，其实坦白说，可以说叫面对 NPE 的诉讼是无解的啊。如果说对 NPE 足够的 professional 的话啊，但是呢，显然每个人的操作水准不一样，所以呢，通常的应对方式就是，比如说像刚才龚教授提到的，这个诉讼管辖地啊这种。最基础的方式呢，其实上是可以去做一些回应。那么，如果把这个诉讼移到一个对这个 NPE 本身不太友好的地方的话，那么很有可能这个 NPE 的这个诉讼呢就会失败。那另外还有一些比较常见的，比如说所谓的釜底抽薪，那你可以去把这个 NPE 的专利给无效掉。当然，另外目前其实大家可以很常见的一个。就是尤其是发生在一些大型的这个企业和这个 NPE 之间呢，那就是另外一个所谓的叫反垄断的一个回应。那么通过反垄断的方式呢，去约束 NPE 啊，这个实际上是就是目前常见的几种叫你要去正面应对 NPE 的方式。实际上有时候呢，我们还要换一个视角啊，我始终强调，就知识产权一定要当这个商业工具来用。那 NPE 实际上有没有反而被你所，实际上这个也是可以去思考的。毕竟是做生意嘛，所以要从所谓的生意的这个叫maximization 对吧？这个利益最大化这个角度去看，当然可能还会有人提出说，那会不会叫惯坏的 NPE 啊？那这个话题实际上可以讲很久，或者扩大到很大的程度啊。这个今天我们就不展开了啊。谢谢你的提问。So Jessica, also back to Professor Gong's question. I think now the Western District of Texas is bringing more and more cases over there due to Judge Albright.
Due to what?
Western District Court in Texas.
Yes.
Before Eastern District, now it's Western Court of Judge Albright.
Judge Gilbreth and Judge Albright.
Yeah. I believe Alan, Albright is handling, according to some reports, he's handling kind of maybe 60% or maybe more patent cases. That's interesting.
There
Okay,
are, it's kind of dull in Western Texas. It's kind of dull in Eastern Texas. And there are judges who like fame. So yes, I mean, forum shopping is a very important aspect of all litigation, but especially in patent litigation in the United States. So from China's perspective, if you are brought into a lawsuit in the United States, you want to try to move that litigation to a forum that would be better for your interests instead of letting the US company control the forum. You would seek to remove the case from a patent court and bring it to a non-patent court,
Yes, nice tactic. Thank you, Jessica, for the input.
Yeah. Jessica, I have another question that is, we know that litigation is one way to solve the IP dispute. Another way is arbitration. Can you tell me some information about the in the United States, the people or the company to solve the IP dispute by means of the arbitration?
Well, usually disputes, when you enter into agreements with companies with technology transfer or with some sort of agreement to share technology or to use to license a patent, usually in those agreements, there are built-in clauses that say disputes will be solved or solved by arbitration or by mediation. And at that point, the parties involved can specify the type of arbitrator they would like to use, or the type of mediator, or even name one specifically. And that's everything in America is founded on this freedom to contract, and so that you can craft agreements and agree to them and create legally binding contracts as you desire. Now, this is, and that has traditionally worked for a lot of patent disputes, that people have agreed to be bound by the decision of an arbitrator or the decision of a mediator instead of using the court system. They have contractually agreed to a different form of dispute resolution than resulting to the US court system. And that has been done in the patent area a lot because of the uncertainty of the court system, because of the complexity and specificity of patent law, and that many judges in the US, I mean, they are judges over all US laws, and they're not familiar with patent laws, and quite frankly, they get it wrong, which means there's the added expense of having to appeal that wrong decision to the federal circuit. And so this alternative dispute resolution has gained a great deal of use in the modern patent law. But a problem has come into this in the past 10 years with the evolution of the America Invents Act and the new administrative proceedings on patent validity before the USPTO, the IPRs and the PGRs that I'm going to be talking about on Saturday. And that is, the Patent Office has decided that they're not bound by these contractual agreements. And so even though a party has a contractual agreement for arbitration to resolve disputes, an aggrieved party can still challenge the validity of that patent in the administrative court at the USPTO, not the legal system court, not the judicial system court, but in the executive branch court at the USPTO. And those judges have decided, we don't have to follow that, and we're going to hear this dispute. And so that is a huge, there was a decision last week that I'm going to be adding to my slides for my talk for you guys. That is a huge thing, that contract law about patent disputes is being disregarded by the USPTO right now. And I expect that will go to our Supreme Court within 2 years to be decided. So right now there's uncertainty about your ability to arbitrate your disputes. As for who you pick, there are hundreds of arbitrators in the United States, if not thousands, and there are many that people like me that have been 35 years in the IP system can become arbitrators and sell our services to render decisions outside of the court system for disputes. And you just have to find someone and know them and write them into your contract and still try that. But yeah, that whole system is it's at risk now, because the Patent Trial and Appeal Board has decided they are not bound by those agreements, and they will hear a patent dispute, even with that agreement in place.
Oh, okay. So powerful.
Yeah. Crazy times.
Okay.
Thank you for that question.
Thank you. Thank you.
Okay, let's see if we have more. OK， 如果大家没有更多问题的话，我们今天的课要不就到这里。Jessica 老师也讲了，就是一直在讲，可能也比较辛苦啊，大家也可能也比较辛苦啊，我们的时间也比较晚了啊。OK, Jessica.
Thank you so much,
Yep.
everyone,
No
for
more
your
question for
time
now.
today.
But I believe they may contact you later, you know.
Absolutely.
They have your, you know, yeah, have your contact already.
Yes.
So
You will have
again,
my
thank
slides. Thank you so much for this opportunity to share with you. I really appreciate it. Thank you.
Okay, thank you, Jessica.
Have you here.
Thank you,
Yes.
Jessica. Thank you.
So thank you so much. And so thank you, everybody. Please keep an eye on our coming webinars. We are looking forward to meet you again. So see you next time, Jessica.
Okay.
Bye-bye, everybody.
Bye.
Bye-bye.
Okay.